more recent cause number first. That's 17-2-615-234. That matters on for presentation of order. And so if the parties would go ahead and put their appearances on the record.
Good morning, Your Honor. My name is Joseph Thomas for Plaintiff Brian Cortland.
And Eric Eisenberg for the defendant Lewis County.
Good morning to you both. So this matter comes before the court, the 17-2-6152, regarding the proposed order. And I want to start off this hearing by indicating that I appreciate that the parties clearly have taken to heart what the court has asked, which is that the parties, when possible, work together. And I just want to compliment you both, because it's clear to me that while you both have continuously strongly advocated for your respective clients, there were times when I think the rhetoric may have gotten in the way of communication on things that the parties could communicate about. And I didn't have any of those concerns regarding what was done here. I wanted just to acknowledge that I thought both of you maintained your strong advocacy for your respective parties, but did so in a way that I thought you both not only did that strong advocating, but you also did so in a way that I thought was very respectful and professional, and it's appreciated by the court. So thank you both for that. The particular issue in this case, there were a couple. Mr. Thomas had put forth his proposed order on the merits, which had a great deal of agreement. There was one thing that I noted in the proposed conclusions, and that was number 12, which I know number 12 was based on a quote from the court's oral ruling, which, as I read that quote, was perhaps not the most clear quote, but the translation that made it into paragraph 12 was even less clear. And I don't believe it's a conclusion of law in any case. The quote was actually, and I went back and I looked at it because it read oddly to me, and the real quote reads oddly too, but it's, Lewis County has put forth a difficult to follow, cobbled together attempt to do that, meaning show that an adequate search had occurred, which has made something that should not be complicated, it has made it complicated. That idea is captured in one of the findings of fact as well, and so I'm going to strike paragraph 12, but the argument that the parties had was regarding conclusion of law 17 and 18. And Mr. Thomas, I just want to set the stage. I certainly will allow both you and Mr. Eisenberg to speak, but it struck me that you had taken the position, which honestly I think has a lot of logic to it, that if there's not been an adequate search, Lewis County needs to do an adequate search. How can we have a penalty hearing without knowing that search has been done and what the results of the search were? And so I'm satisfied that I understand your position. The one question I had for you, and I'll give you an opportunity if there's something you want to clarify as well, but the one question I had for you was the 10-day requirement in proposed conclusion of law 17, and whether that was something that had been discussed with the parties, because I'm aware that there were many records and 10 days seemed ambitious, but I'm willing to hear from you on that point or any other point that you'd like to raise.
Thank you, Your Honor. So we, and we're fine with striking paragraph 12, just to put that out there. That's perfectly acceptable. And just to give you some background, I was very pleased that Lewis County and defendants and plaintiffs could work together on this proposed order. And in fact, we came to a lot of compromise throughout the whole order. And pretty much the only paragraphs that we couldn't compromise on were paragraphs 17 and 18. And so we just kind of kept the language in there as we originally had it, and we had 10 days, and we're open to giving Lewis more time in order to perform a search, an adequate search pursuant to the Public Records Act if they need more time. That was just kind of a number that we put in there as what could be considered a placeholder. So I don't think this needs very long at all, but our argument is that Lewis County agrees with paragraph 13 and 14, and paragraphs 13 and 14 state that, as a matter of law, Lewis County improperly withheld records because it failed to meet its mandatory burden of proof identifying it performed a sincere and adequate search. So if they agree that they haven't proved that they performed a sincere and adequate search, this court needs that proof before it can make a determination on how many records are withheld. And this court has been through other Public Records Act cases before, and it knows one of the components for the penalty hearing is a determination of how many records were withheld. And so plaintiff's position is that as a matter of law, there needs to be an adequate search done in order for that argument to take place before the penalty hearing. And that's the plaintiff's argument.
Thank you, Mr. Thomas. I appreciate that. Mr. Eisenberg?
Thank you. I'd like to make two very preliminary points. The first is that I reread my brief for today, and it has several typos in it, for which I apologize to both counsel and the court. The second is that I want to make clear, because Mr. Thomas indicated, I'll slow down. Mr. Thomas indicated that Lewis County agreed with certain portions of the order. I want to make clear that we do agree as to the form of the order. I didn't want it to sound like as though we were waiving any claim that the substance was incorrect.
And I took it as such, Mr. Eisenberg, that you were agreeing as to the form, but not necessarily that you're preserving your issues regarding whether the court ruled correctly.
Thank you, sir. With regard to the search issue, specifically, I think Your Honor has correctly stated the nature of the argument for Mr. Thomas. And in a general sense, in a vacuum, that wasn't this case, I think it has a lot of compelling logic to it. But it's very hard to map that to this particular case for two specific reasons. On the facts of this case, Your Honor ruled that Lewis County was producing records, that there had been no stoppage of records. I think that's the quote from the transcript. But that it hadn't adequately explained to the requester what it was doing, where it was searching, which was something the requester was entitled to know. In a case in which the ruling is that the search was ongoing, but that the county failed its burden to prove that that ongoing search was adequate, it is very difficult to figure out what the scope of any research should be, particularly since here, after the lawsuit was filed, the evidence before Your Honor at the time of the merits hearing was that one day before the lawsuit was filed, there was further communication regarding continuing work on the request. And that after the request, work continued until Lewis County offered the next installment of records to Mr. Cortland and said, you have to pick these up by X and such date, or we'll consider the records abandoned, and then he did not do so. So it's very difficult to figure out, and this was the rub with trying to negotiate this with counsel, what is the scope of the research in light of the fact that Mr. Cortland has abandoned further records beyond the point at which he no longer wanted them, or no longer would claim them. The second issue that makes it quite hard is that, again on the facts of this case, Mr. Cortland submitted his request on a particular date, and Lewis County had certain records at that time. It then began working on the request and was producing records to him when two other people later requested the same exact stuff, same wording. By the time they requested it, Lewis County had a lot more records that it had acquired. And it decided, as explained in the letter that's in the evidence in this case, that it would, to treat Mr. Cortland equally with those people, it would give him all of the same stuff it was giving to the newer requesters, even though those records post-dated his request. And typically, as a background matter, one does not have to provide records that are not at the agency at the time of the request. You get the records that exist at the time of the request. So these two issues make it hard to determine the scope of what should be researched here. As I indicated, and as Mr. Thomas has indicated, we negotiated, and Lewis County is willing to do a research, but we need guidance from the court about these two issues. Lewis County's position is that, frankly, the court ought not to order the research at all, and instead should impose penalties at
How would the
transducing
court do
costs.
that? What would be the guidelines for how the court would impose penalties? I saw that you had made that contention, but that would be, I don't see how that would be anything but an arbitrary picking of a number.
Well, not because of the abandonment argument and the time of the request argument. So if during the course of the lawsuit, Mr. Cortland has a date certain where he declined to take records after a certain point, and he's therefore abandoned any search or response beyond that point, then you have actually a constrained body of records that are at issue. So you could determine which records are at issue.
How do you know what records a reasonable search would uncover?
Well, because the search was ongoing and the records were being provided, Lewis County would produce evidence about all of the locations that it had been searching and where it was providing records from until Mr. Cortland abandoned the request. And then that would be the body of records that the court would use to determine the application of the penalty. Let me shift to explain why I think this makes sense. If Lewis County just goes ahead and redoes the search, suppose that it finds or decides that there's a body of places it should look that it was either planning to look or hadn't considered at the time Mr. Cortland abandoned his request. In other words, suppose that it goes out and does a greater search than it had already done when Mr. Cortland abandoned the request. That would be Mr. Cortland then end running the fact that while the search was ongoing, he said he didn't want the records anymore, and therefore Lewis County wasn't under an obligation to provide him further records after that point. I guess what I'm saying is this is an unusual case in that it is unusual for there to be a claim of an inadequate search while the search is ongoing, and the implications of that are such that a full research for the request is not appropriate. Instead, if a research is to be ordered, the research should be more limited to those areas that were within the scope of the search and request before Mr. Cortland abandoned it. That also should include only those records that Lewis County had at the time that he made the request, and not those records that Lewis County acquired after the time of his request. Very specifically, there's a body of 3,682 records that Lewis County acquired, or actually, I want to be very clear. The Lewis County Prosecuting Attorney's Office was the agency to which this request was made. During the lawsuits, after Mr. Cortland's request, the Lewis County Prosecuting Attorney's Office acquired 3,682 documents as part of its obligation in the lawsuits to give Mr. Cortland records. And it was provided to him through counsel. Particularly that body of records, which did not exist within the Lewis County Prosecuting Attorney's Office's control at the time of Mr. Cortland's request. Certainly those documents should not be, we should not have to redo that search, because that was not something that Mr. Cortland was entitled to for this request, even though Lewis County, in an effort to try to be fair to him, to try to do its job under the PRA to promote access to records, decided voluntarily to give him those records because other people were getting them too, and we knew that he wanted them. If you're looking for the evidence at that specific point, that's okay. So that's the sort of the rub. That I appreciate the fact that Your Honor may wish to order some further discovery in the form of a research But I don't know how to map it to the weird facts of the case. And so that's really why we're here today, right? We need some guidance from the court about how you square that further search with the abandonment part and the voluntary suspension of the request part. Thank you.
To the court's mind, and I'll hear from you, Mr. Thomas, but to the court's mind, this is a simple matter. This is do a search related to the request that was made and have it be compliant with PRA case law. It does not seem complicated. Mr. Thomas?
Your Honor, plaintiff would agree. This is not complicated, and defendants are adding new things in the record that were not already there, like an abandonment of the request. And they're talking about, well, they've already done a search, but that search wasn't pursuant to the Public Records Act. And the law requires, which I think this court just pointed out, that Lewis County is required to do, in order to provide an adequate response, is required to perform an adequate search under the Public Records Act. And that's all we're asking them to do. We're not asking them to produce documents that were created in the future from their request, but any of the documents that would have been reasonably available, regardless of whether they're claiming an abandonment, because that's a brand new argument that's raised, but any document that was available at the time that they would produce under the Public Records Act.
I'm going to sign that order. The only, Mr. Thomas's proposed order, I think it's correct. The only thing, I guess, my thought, and it's with the clarification that was just made that will hopefully be of help to Mr. Eisenberg, but the amount of time, I didn't hear from you on that. How much time would Lewis County need to be able to do this? And I want to be sensitive to the fact that I'm aware, based upon what you have put forth in the record, that this is a resource issue in terms of people time. What would be the request of the county regarding when this would be done?
So I think we will try to do it as soon as possible. I would request that the order be changed to reflect 30 days instead of 30 calendar days instead of 10 business days. This is not to say that we will take that whole time. If we can do it in a shorter time, we will. May I, in light of your signing the order, may I ask, just to be
And
clear?
I haven't had that officially because I know we're still, there could be small changes, and I know Mr. Thomas has a copy and I'll be submitted up. But I've indicated I would sign such an order.
Right.
30 days, calendar days seems appropriate.
Yes, we would agree to that.
Thank you. Yes,
So-
Mr. Eisenberg. And then I will tell you that I'm going to take a court recess, and then unfortunately there's some other matters that I think might resolve a little bit quicker. So when we come back from the break, I'm going to try to deal with those matters, and then we will then hear the 17-2, 52, 39, 34 costs.
So the other issue that I wish to bring up before the court signs this order is that Lewis County had requested a few additional findings of fact.
I saw that, but quite frankly, I think Mr. Thomas's order is accurate, and that will be the form of the order.
All right. And then the last question I have for clarification is, may I change this to 30?
Yeah, sure. And you can cross out paragraph 12 too.
The last question I had is, it sounds like Mr. Thomas's representation was that they understood this order to reflect only records in existence at the time the request was made and not after required records. Is that your Honor's order? In other words, that we will look at the records, we will search for the records that Lewis County Prosecuting Attorney's Office had, any and all such records that were responsive as of the date the request was made.
Right, to the request that was made.
Thank you, sir.
You're welcome.